Hello and welcome to the Minimum Competence episode for Tuesday, March 11th, 2025. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, Trump SCOTUS shortlister Judge James Ho quitting the FJA, the Supreme Court taking a case on Colorado's conversion therapy ban, and elite colleges fighting higher endowment taxes. Let's remember, the person who does not read has no advantage over the person who cannot read. And read today's legal news. On this day in legal history, March 11th, 1941, President Franklin D. Roosevelt signed the Lend-Lease Act into law, fundamentally reshaping U.S. foreign policy during World War II. The legislation empowered the president to provide military aid to countries deemed essential to American national security, even if they could not immediately pay for the supplies. This marked a decisive shift from the nation's prior isolationist stance, allowing Roosevelt to support the Allies without directly engaging in combat. Under the act, the United States sent over $50 billion in war materials to nations such as the United Kingdom, the Soviet Union, and China. This aid included weapons, vehicles, food, and other critical supplies, strengthening the Allied war effort against Axis forces. British Prime Minister Winston Churchill described the act as crucial to his country's survival, calling it, quote, the most unsordid act in the history of any nation. The law also laid the groundwork for closer U.S.-Allied relations, ensuring American economic and military influence in global affairs. While many supported the act as a necessary step to combat fascism, isolationists in Congress criticized it as a step toward war. Their fears proved correct when Japan's attack on Pearl Harbor in December of 1941 led to full U.S. involvement in the conflict. Lend-Lease remained in effect until September of 1945, helping to shape the post-war world order. The program reinforced the role of the United States as the, quote, arsenal of democracy, a term Roosevelt had coined to describe its industrial and military production for the Allied cause. The principles behind Lend-Lease also influenced future U.S. foreign aid programs, including the Marshall Plan. By prioritizing strategic alliances and military support, the act cemented America's role as a dominant force in international relations. U.S. Circuit Judge James Ho resigned from the Federal Judges Association, or FJA, over its recent statement addressing rising threats, criticism, and violence against the judiciary. Ho, a Trump-appointed judge and potential Supreme Court nominee, objected to what he saw as a selective concern for judicial independence. The FJA, which represents over 1,100 federal judges, warned against irresponsible rhetoric and security risks, but did not name specific cases or threats. The statement came amid increasing attacks on judges from figures like Elon Musk and Trump allies, particularly targeting those blocking conservative policies. FJA President Judge Michelle Childs cited growing threats, including intimidation and impeachment efforts, as challenges to judicial independence. Ho criticized the group for not issuing similar warnings when conservative justices like Brett Kavanaugh faced threats, arguing that defending only certain judges politicizes the judiciary. He announced his resignation at a Federalist Society event, framing his departure as a stand against perceived bias. The FJA did not respond to requests for comment. Fun fact about Judge Ho, this apparent champion of an apolitical judiciary: he was sworn into the Fifth Circuit by Justice Clarence Thomas at a library owned by Harlan Crow. Longtime readers of Minimum Competence or my column will remember I featured Crow in a column back in 2023. We've learned much about Crow over the past few weeks as a friend and benefactor of Justice Clarence Thomas, a collector of Hitleriania and Garden Gnome versions of history's greatest monsters, and a holder of a cash port, I'm coining that term here, to St. Kitts and Nevis, another country that is well known as a tax haven. Some call them golden visas, but that's a euphemism intended to give the entire process the air of legitimacy. James Bond carries a golden visa. Harlan Crow buys a cash port. The U.S. Supreme Court has agreed to hear a challenge to Colorado's ban on conversion therapy for minors brought by Christian therapist Kaylee Childs. Childs argues that the 2019 law violates her First Amendment rights by restricting her ability to counsel clients in line with her religious beliefs. Colorado officials maintain that the law regulates professional conduct, not speech. Lower courts upheld the ban, citing evidence that conversion therapy is harmful and ineffective. The Supreme Court's decision to take the case follows its recent pattern of ruling in favor of religious interests over LGBTQ protections. The court previously declined to hear a similar case from Washington state, though conservative justices dissented. The case will be argued in the court's next term, starting in October. The ruling could have nationwide implications, as over 24 states have similar bans. The court is also considering other cases on LGBTQ and religious rights this term, with decisions expected in June. Wealthy U.S. colleges are ramping up efforts to fight potential tax increases on their large endowments amid growing Republican scrutiny. The Trump administration's recent decision to cut federal funding to Columbia University over alleged anti-Semitism is just one example of political pressures elite schools are facing. Universities like Harvard, Princeton, and MIT are intensifying lobbying efforts, with leaders traveling to Washington to protect their multi-billion-dollar funds. Critics argue that these institutions, which already benefit from tax advantages, should not be allowed to accumulate vast wealth tax-free while tuition remains high. Some proposals in Congress seek to raise the current 1.4% endowment tax or expand it to include schools with smaller per-student endowments. Universities warn that higher taxes could reduce financial aid and deter donors, affecting students who rely on scholarships. The fight comes as Congress prepares for a major tax policy debate in 2025, with Republican lawmakers pushing for broader tax reform. Some smaller institutions, like Wabash College, fear they could be unfairly targeted, despite having far fewer resources than elite schools. Meanwhile, top universities continue to brace for further financial and political attacks, with some implementing hiring freezes in response to federal funding threats. And with that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, you can leave a rating or review in your podcast player. We'd sure appreciate it. And if you know someone that might be interested in a story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it's certainly not that. Minimum Competence is available at minimumcomp.com or wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, if you tell the truth, you don't have to remember anything.